Welcome to the podcast of Studio Central and Eastern Europe at KU Leuven. In our 20-minute episodes, we discuss latest academic research on this region. I'm Wim Wijmans and I'm a research affiliate at KU Leuven at the Leuven International and European Studies Institute, as well as the chair in European Values at UC Louvain. So in today's episode, we will focus on an important juridical procedure against Hungary and the implications it may have for the role that European values play in the European Union. With me to discuss this topic is Antoine Bailleux, who is Professor of European Law and Legal Theory at UC Louvain and Dean of the Institute for European Studies. To understand the importance of the case against Hungary, it may be good to start with the way legal scholars traditionally looked at European values. These values are mentioned in the famous Article 2 of the Lisbon Treaty that reads as follows. The Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities. These values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. As a non-legal scholar myself, I would presuppose that such a solemn article would often be used by European judges when they try to enforce EU law. But apparently, until recently, this Article 2 was rarely used by European judges. Why was that the case?
Well, that's true. Until, I would say, 2016, 2017, it wasn't used at all, or hardly, because it is a very vague article, and the notions that are used in that article are also very vague, very general. Human dignity, freedom, democracy. These are concepts that can give rise to many different interpretations, and it's always dangerous for courts to start using such powerful, wide-ranging words, to rely on them in order to consider that a country infringed EU law. They are more comfortable with more specific, more precise concepts and rules. These rules can have what is called direct effect, so it means that it can be enforced in court. And until recently, that wasn't the case for the values. But then starting in 2017, 2018, things started to change, first with the rule of law value, because the court said, well, even though it's a value, it is also a principle. And principles, well, that is something that judges are more comfortable with. That sounds more like a legal concept. These are also general concepts, but slightly more precise.
Can you give an example of a principle that is more precise as opposed to a value that is too vague?
If you think about, for example, the value of equality, you would say that equality is a very general value. It can be formal equality, substantive equality. While in the treaty, for example, in the Charter of Fundamental Rights, you will see, for example, the principle of non-discrimination, which is slightly more precise. It's still very vague, but slightly more precise than a general value of equality. But it's true that it's not easy to draw a distinction. For example, the concept of human dignity is both a value and it's also a right if you look at the Charter of Fundamental Rights. So these are not watertight, clearly compartmentalized categories. There are links between the two. But values usually is not a legal category. It's more like a philosophical category or a political category, but not so much of a legal one. It's very hard to invoke values in courts. You will usually have to invoke a principle, even though it can be simply a different bottle, but the same liquid in it, the same content.
So up until recently in the European Court of Justice, people would not even bother to refer to Article 2. Is that correct?
Well, you could invoke Article 2, but in order to, let's say, guide the interpretation or influence the interpretation of another treaty provision. So as an interpretive guidance, but not per se as a legally enforceable provision.
Traditionally, any breach of the values as defined in Article 2 would have to be sanctioned through Article 7, which is a political procedure.
Yes, as soon as far-right parties started to gain power in the EU, procedures regarding values were instaured. Think about, for example, about Austria in the late 90s with Jörg Haider, for example. And that's actually the moment when this procedure of Article 7, this procedure that allows the Council to take sanctions against the country, that's the moment when it was created. But then this Article 7, so-called nuclear weapon, was never actually successfully used because there was a political deadlock. It was not possible to gather enough support behind proposed sanctions or even the finding that there was a risk of violations. And so maybe that's the reason why at some point the court and the commission started to consider that they had to take that up themselves through courts.
So one could say that the drafters of the Treaty on European Union saw the Article 2 as an article in which values were defined, which was meant for politicians to interpret and possibly sanction a country that was in serious violation of these values through Article 7, and that this was not something that the judges of the Court of Justice would take upon themselves to enforce. So European values were not typically invoked by legal scholars or by judges in the Court of Justice in Luxembourg, but then something happened in 2022. The European Commission launched a procedure against Hungary, and that proved to be something of a game changer, a historical case when it comes to the use of European values.
So that's indeed a game changer, potential game changer. We're talking here about Hungarian law that tries to allegedly protect children and people minor of age from having access to content that would, in one way or another, portray LGBTI behavior, including access to movies, series. And that was regarded by the European Commission as a breach of EU values. Now, what is interesting in this case is that the Commission relied classically on a number of regulations, directives, so pieces of EU legislation to say, well, Hungary's law violates these legislations. It also referred to a number of rights of the Charter of Fundamental Rights, like the freedom of expression or the right to private and family life, the principle of non-discrimination. And that could have been enough. But then for some reason, the Commission said, well, I would like to make this case even more important by also invoking a standalone, an autonomous violation of the values of Article 2 of the TEU. That was not necessary to win the case, but they did it, I'm guessing, to send a political signal saying, well, these values, they are important, you cannot mess with them. So that was very new.
So it was the European Commission that actually took the initiative to start invoking for the first time Article 2 as an independent criterion or source to punish, if I can say so, Hungary. But there was also the court that was quite receptive to this reasoning.
Indeed, I already talked about cases back in 2018, 2019, where the court said that some values, because they were translated into principles, could be regarded as legally enforceable. But then in 2022, precisely, in a case that involved Hungary and that involves Poland, the court clearly said, and I quote, that Article 2 is not merely a statement of policy guidelines or intentions, but contains values which are an integral part of the very identity of the European Union as a common legal order, values which are given concrete expression in principles containing legally binding obligations for the member states. So the court made it clear that Article 2 was more than just a political option. It had something more to it. And it's interesting that the court said that in a case that was about the so-called conditionality regulation that allows the Commission to suspend the transfer of funds to countries where it considers that there is a violation of the value of the rule of law. And Poland and Hungary said, well, this is not right because values, they are not legally binding. And the court in that case said, well, actually, yes, they are, at least they are, insofar as they are translated into principles in the treaty. So the Commission was incentivized by the court to try a step further and say, well, now what would happen if we just invoke Article 2, regardless of any connection with principles? And so that's why this case, Commission versus Hungary, is new. So now you can see how it continues, in a way, what the court had already started back in 2022.
And what happened in the mind of the judges of the court? Was there some strategy behind it?
Well, it's very difficult to say. I'm not in the court, so I don't know how things play out. What is for sure is that the president of the court, Koen Leenaerts, who is also a professor at KU Leuven, has long been an advocate of EU values. So I think he probably played a prominent role in the unfolding of this new narrative of the Europe of values.
What does the hearing consist of? So it was basically Hungary, I guess, the Commission, and then the member states who speak out and give their opinion in this case.
Indeed, there was a hearing in 2024 in front of a full court, so that's a fairly rare event. All judges being there, adjudicating on that case. What is also striking is that there were many member states that were also intervening in this case. All of them, so more than 10, all of them in favor of giving Article 2 legal teeth, in favor of the Commission against Hungary. So that's pretty impressive too, because that can backlash on them, of course, at some point.
And that's not done in all cases, that the member states actually speak out.
No, and sometimes it was 1 or 2 member states that intervene. Sometimes they don't intervene in the oral hearing, but they just submit written pleadings. But that shows you the constitutional importance, significance of this case.
Yeah, this full court with all the judges, which is a rare occasion, with all the member states who spoke out often very explicitly in favor of using Article 2. But then a few months later, the Advocate General confirmed what the member states were basically asking, namely to give teeth to Article 2.
Yes, although we do not yet have the court's judgment, we already have the opinion of the Advocate General of the court, Advocate General Chapeta. So the Advocate General is a member of the court, but it only gives non-binding opinions. So it's a first indication of what a member of the EU court would consider to be the right answer. But again, there is no guarantee that the court will follow the reasoning of the Advocate General, although one usually says 80% of the cases, the Court of Justice reaches the same conclusion as its Advocate General. And the Advocate General here makes important, quite blunt statements about the fact that indeed EU values are legally binding, legally enforceable. At least when there is a total negation of the values, then a violation of Article 2 of the Treaty on the European Union should be found. And in this case, the Advocate General says, yes, here we're talking about a negation of the values, a negation of the principle of human dignity and of equality. This whole law is based on the idea that some types of existence have more value than others, which is contrary to the constitutional identity of the European Union. So these are pretty bold statements. What the Advocate General also says is that not every disagreement about values should give rise to a violation of Article 2. One may absolutely agree on the fact that there can be disagreements on the reach and the scope and the content of the values, but there are red lines.
What was so special about this particular case? Because that Viktor Orban violated European values is in itself nothing new.
Well, I'm guessing it's because it's a very serious violation of EU values. For example, there was already a case against Hungary a few years ago regarding the restriction of the right for universities, foreign universities, to set up a campus in Hungary because there was this fear that they would promote Western values. And that case was tackled by the Commission and by the court based on other principles, the free movement provisions, the principle of academic freedom, but these were still pretty narrow. While here we are dealing with what the Advocate General calls a perception of what is a good life. So that really brings us to the core of the European identity.
What exactly is it that makes this case so serious in terms of violation of EU values?
Well, if I get back now to the opinion of the Advocate General, she clearly says this is a way of saying that there are lives that are more valuable than others and choices of life, or not even choices sometimes, of course, that even though they only relate to your own private life, that should be discouraged and that children should be protected against. So typically, indeed, if you are LGBT, whatever you choose to do should be hidden, should not be seen by anyone, especially by children, because they could have a bad influence on the youth.
But again, you could say there is the article on non-discrimination. Why was that not sufficient?
It was sufficient, but again, I think here there is a political idea behind it, is to say, well, this is so serious that we want to add an extra layer, even though it's not necessary.
Is there, according to you, a specific reason why it's a country from Central and Eastern Europe that was in the dock for this violation of Article 2? Or was this just a coincidence? Could it also have been another country?
I think that what we are witnessing in Hungary and what we were witnessing before that in Poland is unprecedented in other countries. So it makes sense, of course, that these were the countries that were targeted. I hope that the same would happen if it were France or Germany or Belgium that would start doing the same kind of things. Is there any specific reason why these problems arose in Central European Europe? Maybe it has something to do with the questions of sovereignty. Countries for a long time have been deprived of their own sovereignty and they just regained it, and then they may feel like they are losing it again to some extent. It's difficult for these countries to accept the idea of an authority that is located in Luxembourg, in this case, foreign judges imposing their views, imposing their, they would say probably their agenda on their countries. Of course, that's absolutely not the message of the European Union, but one may understand why it could be perceived as such. They became members of the European Union 20 years ago, and it's a lot to digest. It is true that the European Union is increasingly vocal and active in the defense of values and rights. It was not so much the case 20 years ago. Maybe these countries, did not expect these kinds of evolutions. But here we're talking about bad faith, I think, defenses, where Hungary and Poland usually refer to their own constitutional identity, saying we do not understand these values in the same way in our own constitutional culture.
Did the Hungarian representative in the court or other Hungarian juridical actors advance legal arguments defending their position or say that they have the right to different legal reasoning?
Their defense is that first Article 2 values are not legally binding. They have never signed up for that when they joined the European Union. And then, of course, that these are vague principles or values, and therefore that they lend themselves to very different interpretations, and that they have their own constitutional tradition, their own constitutional identity that stands in the way of the interpretation that is promoted by the courts in Luxembourg.
Are there other countries from that region that invoke a similar reasoning, like Poland, for example, or that also claim that their own constitutional order or reasoning is not necessarily the one defended in Luxembourg?
Yes, Poland did that too, but also Western countries did that in a number of cases, whether Austria, whether Germany itself, even France. So this has now, let's say, since the early 2000s, has become a trendy, let's say, kind of objection to the primacy of the EU, of EU law, to say, well, there is a limitation to the primacy of EU law, and that's the constitutional identity of the country. And there is some legal basis for that in the Treaty on the European Union. But there is a slippery slope here. How far can you go by invoking the constitutional identity of a country? Because everything can be considered to fall within the constitutional identity. If you are in bad faith, you can stretch that argument very, very far. And so that's why the court usually is distrustful of that argument, and it's only very occasionally that it accepts this idea.
Constitutional identity, do they give concrete examples of that?
Well, for example, in Germany, they have a very specific version of human dignity. That human dignity, since the Cold War, has been granted a very specific constitutional dimension in Germany that is much more important than in other countries. So, for example, they invoke that in order to explain why, at the time, a specific city in Germany did not accept that a laser game that consisted of playing at killing other participants could not be accepted in that part of Germany because of human dignity concerns. And we have the same in Austria regarding the abolition of nobility titles. That was also regarded as part of the constitutional identity of Austria. In France, the principle of secularism is very often invoked as an example of constitutional identity. So you see that usually there are two conditions. One is that it must be very quintessential, really, to the identity of the country, very intrinsically and deeply rooted in the history of the country. And it must be distinctive in the sense that it must be different from what exists in other parts of Europe.
But the fact that other Western countries use that can be seen as a precedent for Eastern European countries to do the same and say, otherwise you're treating us unfairly.
Yeah, exactly. So, and again, Advocate General Chapeta, in her opinion, she accepts this idea that we may not agree with everything. That's really fine. And indeed, not all values must be interpreted exactly in the same way in all the countries. Think, for example, about abortion or euthanasia or even the marriage of homosexual couples. I mean, not all the countries have the same vision of that. But according to her, this dialogue stops when some red lines are crossed and when it's not just about weighing differently the values, but it's about negating the value itself.
Imagine that the court indeed follows the Advocate General. What would then be the ramifications of invoking Article 2 by the court?
Now, regarding Hungary, the consequences would be very clear. They would have to change the law, and if they don't, they will have to face penalties, financial penalties. If they don't pay these fines, well, then no more funding will be received from the European Union. So I'm guessing at some point they will be strong-armed into changing the law.
And there is no appeal possible?
No, and here you are in front of the Court of Justice, so that's the highest instance court.
Apart from paying a fine and being forced thereby to change the laws, there are also other consequences.
The other consequences are the precedential value of this judgment. But if the ruling is indeed based on the finding that there has been a violation of EU values and that the criteria for determining the existence of a violation of such values is clear, then we will know that now this is a new weapon that the Commission has, but maybe not just the Commission, maybe also ordinary citizens going to courts, national courts, against their countries saying, well, this is contrary to the EU values. On the one hand, one finds it very laudable and very nice for the court to do all this, but we should also be aware of the potential consequences for the unity of the European Union, in the sense that the values could then be interpreted potentially differently in different countries. And also because that would probably further increase the anti-European discourse, and especially against courts, right? The dictatorship of courts, the elites, European elites based in Luxembourg or in Brussels, deciding for everyone what they should think, politically correct. But that's also, of course, the danger of this concept of values. It can be wielded very ambitiously, aggressively, hegemonically. So it's the weapon, it's a tool that must be handled very carefully. Otherwise, you will very quickly face criticism that it's a gouvernement des juges, that you're imposing your own view of what a good society is. And of course, it's not for judges to decide what a good society is. So the court will have to use this weapon very carefully. If the court goes down that road, I think it should provide for very strong beacons, very strong guarantees that will not turn Article 2 into a catch-all argument. I would say that if it uses Article 2, it should provide for a clear threshold. For example, like the one Advocate General Chapeta came up for, saying, for example, only if the problem is so serious that it amounts to negating a value, not just having a different interpretation of it, but really negating. And here one could say that when you say that homosexuals should be hidden, well, that's, I think, indeed a negation of the idea of human dignity and equality between all the members of our society. But again, let's see how far the court is willing to go, and let's hope that it won't go too far.
Because otherwise the court risks becoming political.
Exactly.
But provided such a clear high threshold is used, such as a negation of values, you'd think that this could actually be a positive evolution.
Yeah, I think so. But again, even this notion of negation, as you can see, is open for interpretation. When does a negation can be found? So even that will require further criteria, I think, for the court to lay down as the case law will evolve. If the court does that, then more cases will come, and then case by case, it will start creating a clear case law about this notion of negation of values.
Well, thank you, Antoine Bailleux, for helping us understand these recent developments involving Hungary, the EU, and European values. We look forward to welcoming you at another episode in the podcast of Studio Central and Eastern Europe. Goodbye for now.
Thank you. Bye-bye.